Okay, so I think we'll go ahead and get started. I want to just be mindful of everyone's time and make sure everyone gets to go eat their dinner after this if you haven't already. So my name is Allison Fine. I'm a clinical social worker, but I also serve as the executive director for the Center for Chronic Illness. And I, want to also introduce Elizabeth Green and Stacy Monahan Tucker, both with Kantor and Kantor, and Stacy also happens to be one of our CCI board members as well. I'm going to let them introduce themselves a little more in depth here shortly. But Elizabeth, if you could advance the slide, I'm just going to chat for a couple minutes about CCI for those who are new to our organization. Thanks so much. So the Center for Chronic Illness, we're a smallish grassroots nonprofit. We are based in Seattle, Washington, but we have programs that serve people from all over the country, as well as some small handful of other countries as well. And for those of you who are familiar with us, you probably know our main program that we offer is our free chronic illness and caregiver support groups. And over the course of the last, 6 years, we now offer over 20 support groups. And all of them are facilitated by licensed mental health professionals, as well as our master's level interns that we get each year from some of the local universities in Seattle. And then, as you probably figured out by tonight's program, every so often we also offer health education programs that just kind of speak to different topics that relate to a lot of folks living with different kinds of health challenges. And so, again, tonight, hoping to share some information with you about chronic illness and insurance. And then finally, I want to mention on our website, we do have a resource list of chronic illness mental health professionals. And, our interns are always working on expanding that state by state. So if you live in Washington or live outside of Washington, you're welcome to check that out if you are looking for a one-on-one counselor or therapist. Okay, next slide, please. And our mission for the Center for Chronic Illness is really to promote well-being and decrease isolation for those impacted by ongoing health challenges. And we do this through our supportive and educational programs and, over time, hope to just continuing offering more and more in this way. Okay, next slide, please. And you can read through our CCI values here. Our goal is really just to offer safe, compassionate spaces for folks to come together. We recognize the challenges that exist when you live with ongoing health challenges and really want to just provide a space that we previously didn't see out there in the community. Either there were organizations that were for specific illnesses, but that weren't inclusive to everyone. Okay, next slide, please. So just real quick here, again, those of you who've attended our programs before, you're probably aware we, again, have over 20 support groups. We host these all virtually at this point. So if you are interested in our support groups, feel free to go on our website. Again, I will put that in the chat again while Elizabeth is beginning. But yeah, you're welcome to check out our programs. Feel free to email us anytime. We're happy to help point you to the right program as well. Okay, next slide. And you can see our contact information here, my contact information. I'm a solo staff person for the organization, so no matter what email you send it to, I'm going to be the one who probably replies, if not one of our social work interns. All right, and with that, I'm going to pass it over to Elizabeth.
You're muted, Elizabeth.
I was muted. Oh my God, classic Zoom start. Hi everyone, I'm Elizabeth Green. I'm an attorney at Kantor Kantor, and my partner Stacy Tucker's here. And we want to talk to you about health insurance and disability insurance benefits and what we've learned about how you can maximize your benefits. Give you some hands-on information if you're having any troubles that you can maybe take away from this and maybe solve your problem on your own is always the goal, and answer some of your questions. So Stacy, I'll let you introduce yourself.
Hi, I'm Stacy Tucker, and I've been practicing in this field for over 20 years. And as my bio notes, I actually started out representing the insurance companies and helping to, when they were sued, helping to review and settle cases there. And honestly, one of the ones that I felt most uncomfortable with on that side were the people with chronic illness, because there's so many ways for an insurance company to deny those sorts of claims because the way that the abilities of the chronically ill can wax and wane. So this conversation is near and dear to my heart, and I'm glad to be here. I'm also on the board of CCI, which is how we started having this conversation in the first place.
And as I said, I'm Elizabeth. I have a practice that specializes in health benefits. I've been doing just health benefits for over 10 years now. Before that, I did disability cases for patients and claimants. And before that, I did some property insurance. So I really love the health cases. I really love helping people who, when they're at their most vulnerable, the insurance company is denying them benefits, and helping them get their benefits, helping empower them to fight the insurance company to get the benefits they're entitled to. So that's me. This is our firm. We are based in California, where I am. Stacy is up in your great state of Washington. I work around the country. We do health cases wherever. We do disability cases, mainly on the West Coast, but other states as well. We work on a contingency, which means that our clients don't pay us up front. We recover any fees from whatever we're able to recover for our clients. And we do all sorts of employee benefits. So health and disability are what we're going to talk about today, but we also do life insurance, pension, some property cases. And we're really, I'm really proud of the fact that we're really the only law firm that does specialize in mental health claims too. I take a particular kind of specialty to those cases. So just an overview of what we're going to talk about tonight. We're going to hit the highlights. We're not going to bombard you with every detail of what we know in our practice, but one thing that we will mention a lot is ERISA. This is an acronym. We're going to talk about what it is, why you need to know what it is, why it matters. I'll start off talking about health benefits. What are some key provisions that you should look for in your health policies? I know they're very long. I know they're very cumbersome, and you start reading them and you kind of get blurry-eyed. So maybe some quick things you can look for that might be the most important things to look for. How to submit timely claims, what happens when you get a denial, sort of the life cycle of an insurance claim, submitting an appeal, and then how to just have really effective communications with an insurance company. And I'll touch on medical necessity guidelines, which some of you may know about, because if you've been denied for certain treatment or services, there may be some medical necessity guidelines you've been faced with trying to understand. And Stacy.
Now I have to unmute. And then I'll be talking about long-term disability benefits, which most people have through their current or prior employment. And we'll talk about how it works. Again, why ERISA matters in how, legally speaking, the claim is run, and all the different ways that ERISA limits your ability to seek your actual benefits, which can be very frustrating, but there are ways to set it up. The things that the long-term disability insurer is looking for in your claim, what they are likely to do while they review it, and what the next steps are if they deny it or if they terminate benefits later on.
Okay, so starting off, I have to have a sense of humor with both illness and insurance. We just have to make our way through. We're going to talk about ERISA policies and not ERISA, which is everything else. Don't be intimidated by this acronym ERISA. You can understand it. I never knew what it was when I graduated from law school. Most people didn't. It's a very specialized thing, but it actually affects most anybody who has their benefits through an employer. this is going to apply to you. ERISA is the Employee Retirement Income Security Act, 74. It was initially applied to pension benefits. It's developed into a broader law, which governs all sorts of employer-provided benefits, like I talked about, disability, life, health insurance. If you've had an employer you've gotten like different kinds of benefits offered to you. All of those are covered under this act. There are regulations to help protect you, the consumer, the participants of these plans. There's specific procedures that the insurance companies have to follow to give you a full and fair review. That's a really big lingo for us, full and fair review. How you respond to appeals, the right to sue. And the plans could be either insured, which means the employer took an insurance policy out to pay the benefits, or they could fund it themselves. So a really big employer like an IBM, a Wells Fargo, they have enough money that they can put that money in a trust or pay from their own assets to pay for benefits. So that's two ways that the benefits get paid. It's important for us sort of at the legal end, but it's just good for you to know as well, oh, where's this money coming from that's actually paying for my benefits? So without going through the entire regulations, what you need to know is that ERISA does apply to all employers, regardless of size. What it doesn't do is it doesn't apply to government or religious employers. So if it's a Catholic hospital, for example, that's kind of, or church, something like that, it wouldn't cover that employer if you work for a state, county. The participants, if you have been denied benefits, you appeal, you can sue, but it has to be in federal court, and you have to have exhausted your appeals. So that's why we make a big point about doing the appeals and how you do them, because you have to go through this appeal process, which appeal makes it sound like a really complicated thing. It's really writing a letter and explaining why you think they are entitled to the benefits and why you think the insurance company denial was wrong. You can get damages in court for a denial under ERISA, but the benefits are really meant to put patients back where they should have been in the first place. So get the benefits paid, get your attorney's fees and costs paid, maybe some interest, and that's it. You don't get extra contractual damages like punitive damages. You hear about these big numbers in insurance cases. Those do not apply in ERISA cases. The goal was that Congress didn't really want to punish employers too much by having a lot of penalties if they did this wrong, because they want to encourage them to keep providing the benefits. So no jury trials, no state court litigation. It's very streamlined. It's in federal court. That's what it does and doesn't do. It's intended to help the claimants. It's intended to help all the patients. So all these procedures are meant to help you. Like, what can we do to make this process, better for the patient? And it's putting things in writing. The claims procedures that the insurance company uses have to be in writing. Denials have to be in writing. Appeal denials have to be in writing. A note for health claims, which I'm going to talk about in more detail. I'm sure everyone here has experienced getting an explanation of benefits, an EOB, which is the statement of what happens when the claim went to the insurance company, how the insurance company parses out what they're going to pay for, what your obligation is. Those could be a denial. So just remember that. We'll talk about that somewhere later. As I said, you have to appeal. It could be up to 2 appeals. You could be offered more. There's external reviews through state insurance departments now, that kind of thing. But you don't have to do more than 2. You can call it quits at 2 if you want to go to court and sue. Your first appeal, you get some time. It's 180 days. They can't require the first appeal due sooner than 180 days. The second appeal could be as short as 60 days, which is quite a short turnaround. And sometimes we have potential clients call us, and by the time they get to us, maybe it's already 30 days or like 45 days in, and we're like, oh, we're really close to that next deadline. So just knowing your deadlines is really important. For health claims, and this really falls in like the mental health category a lot, if there's an expedited or urgent appeal, which you can certainly request if the need is there, those have to be decided in 72 hours. Otherwise, it's like 30 days. And your denial has to be given with enough time for you to know before the treatment ends. So I'm thinking of like a residential treatment, something like that for mental illness. If there's a date that you're covered through, if the insurance is going to deny past that date, you are entitled to know before that date comes up so you can plan. So what does a denial have to look like? It has to be specific, explaining to you why they're denying it. Now, I should say, these are the goals. Everybody will give me an example of like, well, they said it wasn't covered, or they said it was excluded, but they didn't really tell me why. Yes, they're not supposed to do that. It's a work in progress, but they're not always right. But this is what they're supposed to do. Give a specific reason for a denial. If there's something more that you could have done to perfect the claim, as we call it, if you could have provided maybe medical records, something like that the insurance company needed, and that's the thing that would close the gap between denial and approval, then they need to tell you, we need this. This should not be a game of hide the ball. They have to tell you where to send an appeal, provide the guidelines that they use in making their decision. Again, not hide the ball. You should be entitled to all this to be able to craft your appeal. They can't give deference to the original decision. So if Dr. Jane Smith decided the first decision, the second decision, if there's an appeal, can't just say, yeah, what she said. They have to make a new decision with a new person who looks at this with a fresh set of eyes. And they have to consult. Now I'm thinking in terms of if it's a medical necessity denial, meaning you get a denial that says whatever you're requesting, whatever services you're requesting, they are not medically necessary for you. If you get a denial like that, then the insurance company is supposed to consult with someone, a healthcare professional with the appropriate training and experience. This does not always happen either. I'm thinking of an MS patient that I have as a client right now whose request for medication was reviewed by like a geriatric family medicine person. Like, that's not a neurologist. You really need a neurologist to be able to have appropriate training and experience to give an opinion on that. Okay, so this review is kind of what we already talked about, so I'm going to kind of skip through it. But this is the not ERISA plans. Again, it could be a government or religious employer. It could be, most of the time, this is a policy that someone purchases off the exchange, as we call it. You privately purchase your insurance. That is not covered by ERISA. So sort of the flip side, what you don't get with ERISA, you end up getting. You will likely get a jury trial. There could be testimony and witnesses. There could be discovery, meaning you get to take depositions before trial. The remedies, the damages you could get could be expanded depending on what state law is. So state insurance law really governs what happens if this isn't an ERISA plan, and if the policy is insured as opposed to self-funded. So just a quick comparison, you'll get these slides, but if you want to go back and just look for it, here's a quick cheat sheet on the ERISA versus non-ERISA. So some key provisions for health benefits. I like this cartoon because the prior authorization, which I'm going to talk about first, is the one that I think trips a lot of people up. And it's the one that you really need to know before you do anything, because other things you can look at your plan after the fact and figure it out. But the pre-certification or pre-authorization, you need to do that maybe before you have that surgery, before you ask for that treatment. The penalty, if you don't ask for pre-authorization or pre-certification, is really the same thing, just a different way of saying it. It could be a dollar amount. It could be like $500. I've seen that. Or it could be that they could just deny your whole claim. So it's really important. You don't want to end up missing out on getting your benefits because you didn't make a call or the provider didn't make a call before. The proof of loss is just a way of saying, when do you have to submit your claim? If you have an in-network provider, you really don't need to worry about it so much. They should be able to just seamlessly electronically submit your claims. If you're seeing an out-of-network provider, you may get a super bill, you may get something that you need to submit as a claim to the insurance company. So then you need to know, what's my deadline to do that? I'd say the average range is between like 90 days would be like a really short end to a year and a half. So it can vary a lot. So just kind of look for that and know what your window is. The statute of limitations is what we call the deadline to file a lawsuit. So that's kind of something Stacey and I are going to look at. We're going to say, okay, you did your appeals, or we did the appeal. When do we have to file a lawsuit? And this is usually in the plan. Sometimes we have to just defer to what state law gives us for when it would have to be filed, but it's often in the plan. So we need to know that. And it would also tell you what you need to do before filing a lawsuit. So sometimes it'll say you have to complete the whole appeal process before filing a lawsuit. Well, if the whole appeal process is 2 appeals, you got to submit the second appeal. That's not really optional, just to preserve even the option of going to court later. So the number of appeals and what the time frame is to submit those, that will definitely be in your health plan. Medical necessity or medically necessary. This is, again, like 2 phrases that mean the same thing. If you've been denied some health service, treatment, surgery, whatever, because it was deemed not medically necessary by the insurance company, you want to know what this language is and what guidelines they're using to make their decision. I'll talk more about that, but it's really important. It usually follows some definition that talks about like generally accepted standards of care. That's pretty customary. And usually that means, I don't know, for mental health claims, it's like, well, what does the American Psychiatric Association say? What do these, big nonprofit medical organizations say about what the standard of care is for this particular situation? In and out of network benefits. So it's also really important to know, what kind of plan did you sign up for? Do you have out of network benefits? I feel really badly for people who call us and they're like, they denied it. They said there's no out of network benefits. And I say, oh yeah, you don't have an out of network benefit. Or there's some policies that are sold in California and they have no out of state benefits. You can't get treatment out of the state. Like, this is important stuff to know. For chronic illness, what I would say is, what I see most is there may not be a medical provider in the network who has the specialization you need. So I use like a cardiac condition as a very general example. If you have a cardiac condition, you're going to want to see a cardiologist. The plan has to provide an in-network cardiologist. If they don't have anybody in network, or they don't have anybody within 50 miles of your home, then they have to approve someone out of network, because otherwise your benefit's illusory. Like, what's the point of having the benefit if they don't have a network that meets your needs to get the benefit? A single case agreement is exactly that. It's the insurance company saying, okay, yeah, we don't have anybody in network. We'll agree that this out of network provider can be considered in network for this purpose, just for this, exception. Okay, and then exclusions. Look for whether your treatment or the conditions that you have are somehow excluded from the policy. The lesson to be gained from all of this, and if you walk away with anything tonight, I hope everyone gets a copy of your plan or your policy so you know what is covered. The thing that we can't do is understand what your rights are if you don't have a copy of your plan. That's the thing that kind of guides us through everything. Ask for it in writing. I think email actually is an okay way to ask for it, especially if it's your employer that you need to get the plan from. It's okay to put it in writing to your HR department, which is probably managing that. There are penalties that we can ask for later if there's litigation if you don't get your plan documents within 30 days. So that's something that, like, as attorneys, we're always keeping an eye out for. And I said I would talk more about guidelines. So the insurance company guidelines should be available to you online. Insurance companies often keep their own set of guidelines about all sorts of conditions. Step therapy that I referenced here is kind of one that is really interesting to me now. I really don't like it, but it's a policy that an insurance company could put into place saying, you can't continue on the medication that you've been on that's working really well unless you try this cheaper medication first and find out that it doesn't work for you and then go back to that one that's been working for you. Totally legal. Doesn't seem like it should be, but it is. But you won't know that unless you're able to see what the insurance company guidelines are. You want to make sure they're up to date. It's really great if you have a really solid treating physician. Stacey and I will just cannot emphasize enough how important it is to have a physician who's on your side, who would even look at the guidelines and say, well, that's not right. Like, there's a new study that came out that's XYZ, and so this isn't up to date on that. But it's good to know this is where the insurance company is operating from, because then you can direct your comments to it, but you need to know what it is. Submitting timely health claims. Your in-network provider should do this for you. But again, if they don't, or you have an out-of-network provider and you're doing it on your own, you want to submit a claim form. You want to submit your claims by certified mail or some other delivery confirmation to make sure that they get there, and keep copies of whatever you send. Then, again, talking about the life cycle of the claim, you send in your claim, you would get a denial. Hopefully you don't. Hopefully you get an EOB and everything's paid and hunky-dory and you never have to refer to these slides again. But if you don't, you should get your denial within 30 days. It could be a letter, it could be an EOB that drops a footnote saying this isn't a covered benefit. If you feel like not enough has been paid, that is also a dispute you have about what they did. And that also you would need to appeal. So just because they paid a little bit, you can say, well, we're just working out what they paid. It still needs to be appealed. There's a case I'm working on right now, and it's a mental health case, and literally 2 cents were paid for treatment for mental illness. It was like a residential treatment facility, and like the EOB shows 2 cents were paid. Well, we have to appeal that. I mean, it's not 0 cents, but it's not, I have no idea where the 2 cents came from. But that needs to be appealed. And then the insurance company may ask for more information. This is something that I think drives people crazy. I think it's particularly difficult if you already have the challenge of dealing with chronic illness to have to just go back and forth with the insurance company. They want an authorization. Now they want treatment records. Now they want the claim numbers. Now they want another authorization. I see it over and over again. And all I can really say about that is you kind of have to go through those hoops. You kind of have to just get the right authorization in, get the information provided, because you don't want to end up getting a denial because you didn't give them something that they had asked for. And then your claim is denied, you want to submit your appeal. You can do an appeal 3 ways. You could do an expedited appeal. I said this is something that would be within 72 hours. Sometimes that entails a call between your physician and a doctor at the insurance company. If that happens, it's really great to know what the qualifications are for the doctor at the insurance company. Is this somebody who has any experience or knowledge about your particular health condition? And what are their credentials? And who's paying them? Is the insurance company paying them? Are they an independent doctor? How does that work? We send written appeals. This is really kind of the gold standard. Send a written appeal letter. I'll give you a sample of some language, or you can call. You can just call. I mean, it works. You can say, I appeal. The problem is that it might not be noted correctly on the insurance company side. The person who answers the phone, you're hoping they're writing this and typing this into the system correctly. Maybe, maybe not. I mean, that's why having things in writing, you can confirm what you sent and when. So this is just some very general language. You would have to totally tweak, but some general language for a health appeal letter. You're writing to appeal. You are stating why the insurance company denied the benefits and why that decision was wrong, explaining why this treatment, whatever the request is necessary, and how you met their guidelines. Talked about their guidelines are really important, or why are their guidelines wrong? Because sometimes they are. So explain why they're wrong. enclosing your medical records, which show the support you have for the need for treatment or whatever you're requesting. And then letters of support from providers. As I said, your treating physician is really your partner in this, who needs to support you. I know doctors are really just under siege now from insurance companies denying claims, and they have so much going on. I get that it's a challenge for them to then take time to write a letter of support, but honestly, they can do it. And I've been very impressed with doctors who do take the time to write these letters. They're very passionate and they really have their patient's best interest in mind. And they're sometimes really outraged by what an insurance company is denying. So don't hesitate to ask. It may take a few asks to get it, but it's really important to send that with an appeal. And then again, communicate in writing. Our suggestion is communicate in writing. Take notes of phone calls. I have a client who, no joke, made an Excel spreadsheet of the 116 times she called to try to find a provider in network who would provide, would offer to take her as a patient, would provide the right treatment with the dates, the times, the length of her phone calls. I mean, it was like a piece of work. I've never seen anything quite to that degree, but just say it's good to keep notes of who you've talked to when. The insurance company may not tell you the right thing over the phone. They may get it wrong. So the plan, which you've already requested, you're going to have a copy of, is going to be what controls whatever your benefits are. And as I said, send medical records, your appeal with delivery confirmation. Just a tip that I'm sure everybody already knows already, but if you call and you don't get the right answer, you get a confusing answer, just call again. You'll talk to someone else. They'll give you a different answer, a better answer. And you might need an authorization on hand. If someone is calling on your behalf or you're calling on behalf of the patient, you're probably going to need a HIPAA authorization to get any information conveyed. So kind of keep that in mind. Okay, so that's health claims. Any questions before we move on? I didn't give any opportunity along the way, so I'm sorry. I just was going.
There were a couple sent in already, wanting more information about pre-existing conditions and how to manage that situation, and also doctors who ask for payment for a letter of support.
Oh, okay. Well, the pre-existing conditions, those are not permitted anymore under the Affordable Care Act. So if there are pre-existing conditions, it's because you have a policy that doesn't have to comply with the Affordable Care Act. And the examples that I have seen most recently are international student policies. For some reason, those are the ones that have come our way, or like a travel policy, but I would need to see the policy to kind of speak more to it. But the Affordable Care Act, that's actually one of the really great elements of it, is that no pre-existing condition exclusions anymore. And it does remind me, I forgot to mention right off the top, I'm surprised it wasn't one of the questions because this is often a first question. We don't do Medicare or Medi-Cal or Medicaid appeals or claims. And it's simply because it's a whole other set of rules and regulations. And there's actually not really any attorneys that do that because there's no mechanism for attorneys to get paid. It would have to be completely 100% pro bono. You'd have to know all about this specific area of law with no chance of ever getting paid for your work. So just an aside, if there's Medicare or Medicaid questions. And then the other issue about the doctor asking, I mean, it's really unfortunate if the doctor is asking for money for a letter. I would hope not, but I could see it. I mean, I suppose the doctor's asking for their time to be covered. If they had to show it a deposition or something, they would want their time to be covered. So they can ask for that because you're asking for something sort of on the side. You're saying this is above and beyond. They don't have to give it to you as part of your visit with them. But I will say you should be able to get your medical records free. And sometimes there's good nuggets in the medical records, depending on how well your doctors document. sometimes like there's enough in there that you may not need a letter. So.
And Elizabeth, one more question just came in, which I think kind of ties in with your note about requesting the medical records. How do we find out the qualifications of the doctor reviewing the appeal and who's paying them?
Yeah, very good question. So if it's an expedited appeal, if you get somebody on the phone, there's sometimes what they call them a peer-to-peer, where your doctor talks to their doctor. Your doctor can ask for that information. Your doctor can say, okay, tell me where, who do you work for? How are you getting paid? All of that could be asked. If that's not the case, you can put in your appeal letter, you can say, please provide who reviewed this, what their qualifications are, all of that. I will say that I rarely get a response providing that information. It doesn't usually happen. And it's something that in litigation that we can point out and say, look, we're trying to communicate. We're trying to get a full and fair review. We tell you who the treating physician is. We should know who the physician is for the insurance company who's looking at this. You're totally entitled to it. Whether they give it to you is another story. Oh, and sorry, you could ask for your claim file. Put it in writing, ask for your claim file, and you should be entitled to get everything that they have about your claim. And it should be in that as well.
All right.
Okay.
By the way, you can ask for your claim if it's ERISA. If it's non-ERISA, they actually don't have to give it to you. So just be aware that can be very frustrating. But now I'm going to switch to talk a little bit about disability. And the first thing I want to note is there's lots of different types of disability benefits. There's Social Security. There's workers' compensation. There's asking for workplace accommodations. We're not talking about any of that. We're talking about private long-term disability insurance, which is usually offered through your employer. You can also purchase a separate policy on your own. You may even have coverage that you don't fully know about. For example, when I bought my house, we were offered a rider for disability that will pay my mortgage if I'm disabled. That's all it does is pay the mortgage, but pays the mortgage. So you may have more coverage than you're aware of. Just should you find yourself in a situation where you're needing coverage, you may have more options than you think, including if you were employed and your disability began when you were employed and you left or were terminated, you may, depending on the amount of time that's passed and the situation, you may be able to make a retroactive claim. So don't assume that because you didn't realize what was going on with you, that there was no diagnosis, that you can't go back retroactively. It's very fact dependent. It's entirely possible that you may be able to do that. Yep, thank you. So long-term disability, it provides income replacement. Usually you pay premiums, either your employer pays them or you pay them yourself. If you pay pre-tax, then you can be taxed on the money. If you pay post-tax, then you won't be taxed on any benefits you get. So while you're paying your benefits, if it's coming out of a paycheck every 2 weeks, you may not be paying attention to that. But if you find yourself disabled, it matters because you may be paying taxes on what's now 60% of your salary. So just be aware of that in advance. There's usually 2 levels of disability in a policy. Usually for the first 2 years, you have to be disabled from performing your own occupation. And own occupation is not the same as own job. A lot of people assume that it will be, but it's not necessarily. Let's say that you are a doctor and in your particular job, you're expected to be on your feet working nonstop. However, your own occupation, there may be doctors in your field who sit and do desk work most of the time, and the insurer could very well argue that your own occupation includes that, and you may not be able to do your own job, but you could get another job in your field. So be aware of that. After 2 years, most policies transition to any occupation, and that is exactly what it says, any occupation. We've had some success arguing that any occupation cannot mean that a CEO has to go work at McDonald's, that there needs to be some reasonable tie to education and experience. They can't expect you to go out and become trained in an entirely new area of work. If you can't be asked to become a rocket scientist. But I would say that the court's kind of, it's not 100% clear. I know that when I was on the side defending insurance companies, that was a point where we were able to argue and push back with varying levels of success. So be aware of that after 2 years, and that's similar to Social Security, by the way. Social Security requires you to be disabled from any occupation. So within 2 years, that's the standard you'd be looking at. Usually, you also have to show that you've been disabled for a period of time. It's called an elimination period. Usually it could be between 90 days and a year. 6 months is pretty average. Most employers offer short-term disability coverage during that 6-month period. So getting benefits is kind of, obviously it's a process, but this is another step in the process. First, you go out on short-term disability, which covers almost always your own job, by the way. So that means if you can't do your own job at your own employer. After 6 months, if you are still unable to go back to work, you can then move on to long-term disability. And that's a whole new review because they're looking at your own occupation. They're also looking at whether or not you can work part-time, which, especially with chronic illness, often comes up a lot. So I think we're ready for the next slide now. Long-term disability insurance. Maximum benefit date, usually through age 65, or depending on the language, whatever the Social Security Administration is estimating as the normal retirement age. There are some, especially if you buy it yourself, that go indefinitely. And those are much rarer these days as people are living longer. Insurance companies don't offer them as much. But if you've bought your own disability policy, look at the language. You may have coverage that you're not aware of. Usually it's a percentage of your income, usually between 50 to 70. I'd say 60 to 65 is pretty standard. Again, if you've purchased your own policy, sometimes you purchase a flat amount, say $10,000 a month, and there'll be a cost of living adjustment in it so that that amount increases each year. So it very much depends on what the language of your policy states. And residual disability, that's when you can work part-time. If you are able to work, say, 3 hours a day, but you cannot work a full day, or you can work 2 days a week, but not the full time, what your benefits will do is look each month at how much you made that month, and then make up the difference up to what you would have been owed for benefits if you were fully disabled. And that changes each month based on how much you earned the prior month. And it's usually monitored pretty closely by the insurance company because their goal is always to get you back to work full time. But that is a portion of most coverage to encourage people to work to the extent that they can. Okay, I think we're ready for the next slide. So you're disabled. You are unable to go back to work. Your doctor agrees and is encouraging you to take time off, or perhaps you've had a terrible accident and you know you're never going to be able to go back to work again. Get a copy of your policy. Ask for it from your employer or from your insurance company, especially if it's a privately held one. Policy is what it's called when it's individual insurance, when it's not through your employer. Plan is the ERISA language. They mean the same thing. So if you're talking with an insurer or an employer, just be aware they are, for all intents and purposes, both the contract that governs what the insurance company is required to give you and how they're required to do it. That policy is going to have all the information that governs your claim. It will be, the exclusions and limitations will be spelled out there. The information they're able to ask for is in there, and what to do if your claim is denied. All of that is spelled out in the policy for you. And I think we're ready for the next slide. So what coverage do you have? Read your policy in detail. Feel free to call an attorney. Most give free consultations and will answer questions. I'd say I probably spend 25% of my week answering questions for people who call our firm and don't know if they have a claim, don't know what to do. Sometimes our intake people can answer, sometimes they can't, and they send it on to an attorney to make sure that the information's right. But find out what coverage you have and don't be put off by confusing language. Always ask for documents from the insurance company or your employer in writing. It's very important because they are required to give it to you within a certain period of time. And if they don't, there are actual penalties. If you don't do it in writing, they can say you never asked. And that becomes a he said, she said, which can be very frustrating. So as much as you possibly can, do everything in writing, all communications. Email's fine. You just want to be able to point to it and say, I did this on X date and you responded with this answer. You always want to have everything in writing. And exclusions and limitations that can impact people with chronic illness. There's actually 3 of them. For some reason, I only listed 2, but we're going to talk about 3. Mental nervous limitations. Many policies limit benefits to 2 years if it's related to any type of mental health issue or nervous disorder. Another obviously large one that you're going to encounter is pre-existing condition limitations. Unlike health insurance, those are permitted and are very common in long-term disability. And I think I talk about this more on the next slide, so maybe not. So I'm just going to keep talking about that for a minute because it's really important. For pre-existing conditions, what they're going to look at is if you've been working for less than a year, and this is important, if you've been working for more than a year when you make a claim, almost all policies do not permit them to look at pre-existing conditions after you've been employed for 1 year. So be aware of that. If you have lupus and you've had it your whole life or your whole adult life, and 3 years into your job, you have a flare-up and you need to take time off, that is not subject to a pre-existing condition limitation. If you started your job 8 months ago and that happens, that arguably is. But they're not allowed to go back forever in your life to see what the limitation is. They can usually look somewhere between 3 and 6 months, depending on the policy, before you were eligible for the insurance to see if you were actively treating for that condition at the time. If you were, that's where the pre-existing limitation kicks in and they can deny your claim based on the pre-existing condition limitation.
Stacey, quick question on that point.
Yeah.
So the question is, does the 1 year have to be at the same job or does it span jobs?
Same employer. So if you've been working for 6 months as a computer specialist level 1, and then you get promoted to project manager, that still all counts so long as it's with the same employer. If you change jobs though, you're starting from scratch again. If you change employers, you're starting from scratch again. So be aware of that. Also be aware that just because you were treating for a condition, it doesn't mean it's the same one you're going out for. I actually just won a case on this in Washington. The insured had been hit by a car and had several years of difficult recovery. She was literally crushed and her hips had been totally crushed. She was back at work. She was doing great. She was really excited. She worked for Microsoft. She was on a work trip in China when she felt a pop and all of a sudden found that she was pretty much unable to walk. The insurance company tried to deny it as a pre-existing condition because of the prior accident, and she had received some pain medication for it. By the way, something as simple as pain medication constitutes treatment. So be aware, going in for a follow-up and being told you're cleared and ready for work, that counts as treatment. So keep that in mind as you're figuring out your pre-existing limitations. However, in this case, the pop that poor woman felt was not from the accident. She had impingement. She had hip impingement, which a lot of women have. And she had a labral tear and it popped. And it took 2 years of litigation for the insurance company to be forced to pay her claim, because just because it's in the same area of the body doesn't mean that it's caused by the same thing. It has to be the same condition, not just the same area of the body. So if you have a bad back, for example, and you've been treating for years at your L5-S1 level, and you are able to work with it and you've got everything set up, and then you all of a sudden develop problems in your upper neck, that is not the same thing, and they should not be able to claim a pre-existing condition for that. So be aware that yes, pre-existing condition limitations are in most policies, but they are not as automatic as the insurance companies would like you to believe. With mental nervous, similar issue. Typically the language says if your illness is caused by or contributed to by any type of mental illness, which includes anxiety and depression, which are very common among the chronically ill, because it's really hard to live with this all the time. Insurance companies will say, oh, well, you treat with a psychologist or you take antidepressants, therefore that's part of your disability, and you can only receive at the most 2 years of coverage. Many judges are onto this and push back hard on it, but you should be aware that this exists. And especially if people claim somatic issues. If your doctor or the insurance company claims that your illness, that your pain is somatic in nature, that is a fancy way for them to say that it's all in your head and that it's related to your mental state of mind. And that's another case that we actually just had up in Washington. The judge was very clear that it is not the same thing. If you have back pain and a doctor suggests that a component of it may be somatic, that doesn't mean that you don't have back pain. So be aware of both of those. And the third one that is not listed, but I would like to touch on, self-reported symptom limitations. More and more policies are including a self-reported symptom limitation. So if you have pain and there's no way to test for that pain, or you have symptoms where there's no clear way to test what's going on, you can't figure it out with an MRI or an X-ray, many policies also limit those to 2 years. And that can be a wide range of issues. It can be fibromyalgia. It can be migraines. It can be lupus. It can be a lot of things where the diagnosis is one of exclusion. And so again, there's a lot of pushback and forth in the courts about what the scope of that means. But if your benefits are terminated because of a self-reported symptom limitation, don't assume that's the final word. Same with the mental nervous, same with the pre-existing condition. The fact that the insurance company tells you it's the final word does not necessarily mean that it is. So just please be aware of that. All right, now I can go to the next slide. How do you support your claim? You make a claim, they ask you for information to support. They're going to contact your doctors and ask for medical records. They're going to ask your doctor to fill in an attending physician statement. They're going to ask you to fill in a statement, usually called the Claimant Statement. They're going to ask your employer to fill out something that just says how much money you make, when did you start working, and usually a job description so that they can understand what your job or occupation is. They'll also ask you to sign an authorization for release of medical information. All of these things you need to provide. One thing that often surprises people is that if they take umbrage at a request and feel like they shouldn't have to do it and they refuse, that is legally perfectly acceptable reason for the insurance company to deny your claim. They don't deny it based on the medical records. They deny it based on what they call lack of cooperation. So please be aware, the hoops are frustrating. They're a lot, especially when you're already ill and struggling with your day-to-day life. They are necessary. And you can actually, there are people you can call for assistance with this, including law firms. If you're overwhelmed, there are sources for assistance. They'll usually want to talk to you on the phone. They'll ask you questions. They take notes on the call. So you may want to take notes as well, since their notes are often not incredibly detailed and may put things into a light that you had not intended. You'll provide all medical records. They'll ask you for medical records, but you can go back as far as you need to make sure they have all the information. You want them to have a detailed job description so that if you have a job that requires lots of physical movement, even though there's a possibility that job could be done sitting all day, they need to know that too. If you have a Social Security award, you want to provide that. You want to provide performance reviews so that they know that this isn't you filing a claim because you're about to be fired and you want to keep your income going for a little bit longer. You can provide a personal statement or any journals you've kept of your symptoms. You can provide statements from your coworkers and supervisors. All of this goes into that record, that your claim file. If it's ERISA, any judge in the future is only going to look at what's in the claim file. They're actually not allowed to look at anything outside of that. So if you want any type of information in that file, you need to put it in during your claim or during the appeal. And I think we're ready for the next slide. Your treating physician, just like for health insurance, is huge in this. They are going to call and ask to talk to your treating physician, and they are going to ask him or her to fill out a form. So the first thing you need to do is make sure you're treating with the appropriate doctor. If your primary care physician is supporting you for disability from arthritis, they may ask why you're not seeing a rheumatologist. You may have something like Sorgens, for example, where you need to treat with a bevy of doctors, lots of different specialists who coordinate. Your doctor will need to make that clear to the insurance company, and you may want to have each doctor provide an opinion, because what they'll do is say, well, this one doctor says she's not completely disabled by her ophthalmology needs, but your neurologist combined with your sight issues the two combined may mean that you can't do your job, but each one individually may say, oh, well, this one issue doesn't keep her out of work. You may have 4 issues that combined are disabling. You also need to make sure you're telling your doctor everything. We all like to seem strong and stoic, but if you don't tell your doctor about the level of pain and the consistency of the pain, or the fact that it's not getting better despite all their best efforts, they're going to write in their records that you're doing well. One of the biggest things that can tank a disability claim is doctors writing, oh, steady improvement. You may not actually be experiencing steady improvement. You may just not be reporting that the treatment isn't working, and that's something that you need to do. You also need to remember, if you're on pain medication and it makes you foggy and loopy, you need to say that. If it makes you need to nap in the middle of the day, you need to say that and make sure it's in your record. If your doctor gives you a treatment plan, so long as you're physically able to do so, it's important to follow it, because one thing insurance companies will do will say, well, they were sent to 8 weeks of physical therapy and they didn't go, so they're non-compliant. And if they had simply done so, they wouldn't be disabled anymore. So it's important. Consider that another form of the hoops. You need to jump through those hoops. It's also good, if you are on disability or anticipate filing a claim like that, to get a copy of your medical records. Look through them. Oftentimes, doctors write things down that are just plain wrong. Sometimes they do things at the end of the day, they'll fill in everything and they misremember. or they copy records from one visit to the next and without really making any changes, despite the fact that what you said was quite different in one visit versus another. So ask for a copy of your records, and if you see anything that's clearly inaccurate, point it out to your doctor and get it fixed so that the insurance company isn't relying on it. I think we're ready for the next slide. Again, document your symptoms. Make sure that every time you're in there, you're consistent. You're telling them everything that's going on. If you say you feel like you're doing better, your doctor's going to write that down, and the insurance company is going to take that to mean that you're ready to go back to work. If you say that you're doing okay, or the doctor writes that you're stable, to them, to the insurance company, stable means, okay, you're doing all right. You're probably ready to go back to work. The doctor may mean that you've had stage 4 cancer for years, that's medication is keeping you alive, and that's it. But that's not what the insurance company will hear. The insurance company hears ready to go back to work.
Stacey,
Okay.
a question.
Yes.
If you find an inconsistency in your medical records and you ask your doctor to fix it, what do you do if they won't do that?
Well, the first thing I would do is ask them why. Do they disagree? And if they disagree with you, why is that? That's kind of tied in with making sure that your doctor supports your claim. If your doctor doesn't support your claim, that's going to be a big issue for making a claim. And you should find out why. Have a conversation with them about what they think is going on. And because that will go through into any type of claim that you file. They're going to call your doctor and they're going to ask your doctor. And if your doctor says, oh yeah, I think she could probably go back to work anytime, that is going to tank your claim. So before you make a claim, you want to make sure that your doctor is supportive of it, because otherwise, if your doctor doesn't know, your doctor may say, I didn't know that they were out on disability. This is news to me. Again, that will tank your claim. So you want to deal with all of that up front. And if there is a difference of opinion, you want to know in advance. One thing, if that happens, and if you do this too often, it will harm your credibility, but you can go see another doctor. And if you feel that your doctor doesn't listen to you and doesn't take you seriously, it's totally reasonable to find another doctor. If you go to 9 doctors and it's only the 9th doctor who supports your claim, the insurance company is going to note that and question it. But you'll be accused of doctor shopping. But if it's completely reasonable, especially if you have something that's hard to diagnose or that some doctors don't really believe is real, it's completely reasonable to have to go find a doctor who understands what you're dealing with. So that is definitely something that's okay. And I see the question. Yes, if you ask your doctor for changes via email, that email will be in your records. So be aware of that. It's not necessarily a bad thing, but if your doctor responds in writing that they disagree and it gets into it in the record, that record will be in front of the insurance company. So just be aware of that as well. You may want to have that conversation in a regular appointment as opposed to via email if you think there's a chance that there's an actual disagreement. Because again, your medical records are what the insurance company is going to look at. And if they see a written dispute between you and your doctor about whether or not you're disabled, they're going to latch onto that. All right. Go see the specialists your doctors tell you to go to. Get the tests your doctors ask you for. The one time we would say don't do this is if you're really physically unable to do so and your doctor just isn't hearing you on that. Obviously, we would never encourage you to physically harm yourself just to meet the instructions of your doctor. But most of the time, your doctor's not trying to harm you and does understand your restrictions and limitations and believes that you're capable of doing this, whether it's testing to see your endurance, whether it's a cognitive test, whether it's going to PT. There's all sorts of things that they can ask you to do. And if you are making a claim for disability, you really need to be able to do that. I see the question about phrases you can use to describe against the baseline that aren't the same as doing better. That's a really good question. You can say things haven't gotten worse. That's certainly a way to approach it. You can say, I have the same pain levels I've continued to have. You can say, there's been no improvement, which you're not getting worse, you're just not getting better. And approaching it that way will help make it clear to the doctor that you're not, I'm okay, same old, same old. That to them could be interpreted as you're really doing fine. But talking about how you have not improved will help the doctor or nurse or physician assistant or whoever's taking these notes make sure that they accurately portray how you're really doing.
I might even say, sorry to jump in, but say things are stable. When you look at hospital records, they'll say that a patient is stable. Well, a patient could be in a coma and stable.
Exactly.
Or a patient could be alert and responsive and stable. So that just means like status quo, as Stacey was saying.
Yes, and I've had cases in the last year where the insurance company has argued that they're stable and therefore they can terminate their benefits because they're stable now, they're not worsening. So be aware of that as well. Language is important. And in your verbal communication, you don't want to have verbal communication with the insurance company as much as possible. If you have it with your doctor, which of course you will, you want to be really careful about stating your restrictions and limitations, both with the insurance company and with your doctor. You don't want to say you can never do something because you may not be aware of this. Insurance companies surveil you while you have a claim pending or an open ongoing claim. They send people to your house, they follow you around, and they tape you. So that if you say that you can only walk for 10 minutes at a time, and they see you go for a 25-minute walk while you're shopping, they will use that as a basis to terminate your claim. So long as you're in a public space, that is legal. We actually have one right now where we may file a countersuit because they actually crashed someone's daughter's wedding and filmed them at the wedding and ate the food at the wedding. So be aware. So long as you have either a pending claim or an open paid claim, you could be observed at any time. So if you say you cannot sit for 6 hours and then you take a flight to Hawaii, they are going to note that, especially since travel is often noted in medical records. So if they see in the medical records that you took the trip you've always been wanting to take to Japan, they're going to ask how you did that if you can only sit for 20 minutes at a time. If you can sit for 6 hours on a plane, why can't you sit for 6 hours while you're working? That is their take on it. So never exaggerate, because that's where they get you. They say, oh, well, you said you couldn't do X and we saw you doing X, therefore you're lying. Attending physicians who disagree, like we said, something you need to find out in advance. If your physician doesn't support your claim, you need to know that. Same with inconsistencies between reported activities and physician notes. So it's what you say to your doctor. If you say, I can't ever do this, and then they find out you're doing it, that's a problem. Another one, and I think we talked about this on the next slide, is social media. Oh, never mind. We do talk about social media. No, keep going, because we do talk about all this. So overstating restrictions and limitations. The only way they can legitimately deny your claim is to make you look like a liar. Don't help them. Don't say always, don't say never. Say it varies, that that sometimes some days are better than others. And you can't say with specificity whether or not every day you can sit for 15 minutes. You can't say that, yes, you have to nap for 3 hours every day. It's going to be different. And that is the best way for you to support your claim. Because if every day is going to be different, an employer cannot rely on you. And that's a big part of a chronic illness, is not being able to work, not because you're unable to do something ever, but because you can't do it reliably. And next slide, social media. This is a big deal. And a lot of people don't understand that the insurance company is looking at your social media. They're not just looking at your social media. They're looking at your friend's social media to see if you're tagged in pictures. You may not realize this. If you simply type in someone's name and address on Google, there are sites that track your known associates. An insurance company looks at those and then goes to social media and looks them up and sees if they have posted about doing something with you or traveling with you. So even if yours is locked down, that doesn't mean that everyone you know is. So remember, anything you post on social media, they're looking at. When I was on the other side of this and representing insurance companies, I cannot tell you how many times we were able to show that somebody was not being truthful by having them say that they kept a log of when they were bedridden and comparing that log to their social media, which showed them out and about. It's a big deal. And I think I don't think plaintiff side attorneys take it as seriously as they should. So I want to impress upon you, the insurance company is looking at all of this. They're also having people run background checks on you. They get a whole nice 30-page little report about your whole life. So be aware of that. And just keep it in mind, if you're filing a claim or you're on disability, you need to always be aware that somebody's looking at what you're doing. And I know that's uncomfortable and awful, but it's also true. And yes, the Fitbit stats, that's a really good point. Someone just posted it in the chat about having an open claim and posting your Fitbit stats with a broken back. That is a problem. Credit report, I don't know if they pull your credit report. That's a good question. I don't know that they actually do. I don't recall seeing that. I do know, however, that someone who had chronic migraines and was encouraged to surf because the exercise and the sensory experience of being in the water helped with the migraines. They were surveilled and it was used against them despite the fact that they were literally acting on their doctor's orders. So it can really be a problem. After you submit your claim, you'll get a letter saying that they've got it, giving you forms to fill out. This is when you ask that any contact with your doctors be in writing so that they're not just randomly calling your physicians, which also really annoys your doctors. Let your physicians know that this is happening, that you filed the claim, that you'd already discussed with them, hopefully. Yes, you can be surveilled through home windows. You can also be surveilled in your backyard. Sorry, just looking at the questions popping up here. They can also, there are some who put stationary cameras out in front of your house so that they know anytime you come or go. Or if you have people over, if you're entertaining. So make sure your physicians know in advance, let them know that the insurance companies are going to be reaching out to them. After the insurance company reviews your records, they're going to ask for what's called a peer review. That is either an in-house paid physician who works for them 100% as an employee who contacts your physician to talk about your claim, or they may pay a third party to find a doctor who does these sorts of things a lot to contact your physician. They're still being paid by the insurance company, but through a third party, it's supposed to help keep it more neutral. Obviously, that's not really the case, but that's how they approach this. If there is a significant question about your disability between your physician and the insurance company physician, they may ask you to submit to an independent medical examination with a physician they choose. And this means that they do not think that you are definitely disabled. You have to go to this. If you refuse under the policy, they can deny your benefits or terminate them if you're currently on claim. They may also ask somebody, usually an employee, sometimes an independent contractor, for what's called an occupational analysis or vocational review, where they look at your occupation and how it's performed either in the national or local economy to see if you could do your job somewhere else, basically. And if the restrictions and limitations the doctors have given you really keep you from doing your job. So all of that is happening behind the scenes while you're waiting for your decision. If your claim's denied, if it's ERISA, you get appeal rights. And when I say right, that sounds like, oh, it's a great thing, but it's actually a requirement. So you have to appeal. Usually it's 180 days. under ERISA, and it's in the denial letter, and you have to appeal within 6 months or you cannot bring suit. If that's something that you'd be interested in doing, you've got 6 months or you're done. The first thing you want to do is request a copy of your claim file in writing. They have to send it to you. That's all the information, all the notes they have on you, all the decisions that were made, all the reports they wrote about you. And now we can go to the next slide. After you get that, you can look and see what they based the decision on and where they got their information. To the extent that it's wrong, you summarize why it's wrong. You have your doctors look at it and say, well, that's not right at all, and have them write a letter. You have them provide any information about your claim that would be helpful. You can have your employers write letters. You can have your family write letters. You can write a letter. This is where you can put in all the information that hasn't gotten in there yet. And this is your last chance to do so. So this is where you want to do it. Any problems, this is where you address them. Truthfully, I'd say at least half the time, the appeal is not overturned. They uphold the decision on appeal. But if you think that you're ever going to want to bring suit, this is your opportunity to get everything in there. So half of this you're doing for the insurance company, the other half is for a judge in the future, so that a neutral third party who looks at all this can say, oh yeah, they made a terrible decision. So if your appeal is denied, you can look for counsel. And most will offer free consultations to talk to you about what your situation is, how they can help you, what it will look like. Some will charge you by the hour. Some will do a contingency fee, and that's where they pay for everything up front. They handle everything for free. And if you win, they keep a portion of your benefits going forward. You can also, if you don't want to get involved in litigation, you can make a complaint to the Department of Insurance and ask them to get involved. Unfortunately, they don't have a lot of actual teeth. There's not much they can force the insurance company to do, but sometimes getting the eye of the Department of Insurance on them will make them take a second look, and they sometimes will change their minds. It doesn't happen too often, but it's a possibility. Your other option is to file suit. And do we have another slide after that, or is that it? I think that's it. That is how it works. And I am happy to answer questions. Although I think I may have already got.
We may have skipped a couple, so let me go back and look.
Yeah, Stacy, there was one actually Carmel had asked about if you are self-employed, is it possible to get a long-term disability plan, and what would be the...
It is. If you're self-employed, there are a couple ways to do it. First one is just buy an individual policy. There are brokers who can help you with this. You can call an insurance company directly. Standard Insurance actually has pretty good policies for this. There are a number. They will send someone out to you. It's kind of similar to getting life insurance. They'll do a medical examination at your house, and they'll decide what they are and are not willing to insure you for. They'll also ask for several years back of records showing how much money you make. It's a somewhat in-depth procedure. It's not like just getting it through your job, but it's completely possible. Another way, and it's also a little more expensive that way, just to let you know. Another way you can do it, depending on your profession, a lot of professions that have people who work for themselves have groups like CPAs, for example, or lawyers have the bar association for their area, or doctors have the medical board. Those groups often offer their own group policies that they obtain and then offer to their members. So dentists get them that way. Typically, medical, legal professionals, actuarials, I think actuaries can get them through the Actuarial Society. If you have access to something like that, you may be able to get much cheaper insurance that way. It'll be more like one you would get through your job that way. It'll be a percentage. It won't be as tailored to your situation, but it's a lot cheaper. So that's definitely one option you have.
Stacey, a quick follow-up to that, and I already know the answer to this. This is a little bit loaded, but can you get denied from applying for long-term insurance if you're
Oh, yeah. In fact,
self-employed?
I just did. Yes, you
Mhm.
absolutely can get denied, or they can offer you something that's much less than what you wanted. That's what happened to me. They didn't want to offer me as much as I wanted because I'm about to turn 50. So I decided, you know what? I'm not going to pay for that. I'll go look for something else because that didn't seem worthwhile to me.
Mhm.
So here I am. I am a disability insurance attorney without disability insurance. I'm just pointing that out. But yes, they can deny, they don't have to give you insurance. You need to be really well aware of this. It's also true for long-term care, which I know has been a big issue in Washington. We also handle long-term care claims, and those are really up and coming issue right now too. Life insurance, they don't have to give you any of this insurance. So be aware of that as you try to make sure that you're covered, because especially with chronic illness, there's a good chance that you may need this support at some point, and you want to make sure that you're ready if you do.
So it looks
There's
like
a new question about getting LTD policies for self-employed individuals.
Uh,
Yeah.
it will be a problem. What they may do if you're being treated for a serious health condition is do what's called carving that out. And they'll be willing to insure you, but not if you have to go on disability because of the serious condition you're already treating for. So you'd be covered if you were hit by a car, but not if your condition worsens, and you'd be covered if you developed a new condition, but you wouldn't be covered for your current one. That's the most likely scenario on that. And if you're no longer working because you've been disabled in the past, yes, there's a really good chance you'd be able to get insurance because you left because of ADA accommodation issues. Mm. And yeah, getting insurance while you're already disabled is hard. It's going to be harder. And that's why if you are currently able to be working, you want to get all of this set up now before you reach a point where your illness keeps you from working. Because as we're seeing in these comments, people are finding it, if you're already disabled and you try to get insurance, it's often too late. No insurance company wants to cover you because you're already there. You're already at what the insurance is supposed to protect against.
And there's a question about it. If you request your medical records from the doctor and the doctor's not providing them, there are state laws that require, and they're very different. But I know California passed some really nice laws a few years ago about what the requirements are for production of your medical records to you. So my suggestion would be put those requests in writing so you have that backup and you can keep following up. But yeah, they have to provide them to you.
And if you do make a claim and it's denied, you can also, most law firms will start helping at the appeal stage. You don't have to be ready to file a lawsuit to get the help. And that's true for health too, I believe. We can jump in advance, and that can also maximize the chance of it getting overturned and you getting the benefits. So, and that's not just us, this is anyone. We always encourage people, if you find yourself in the really unfortunate situation of needing a lawyer, talk to a whole bunch. Make sure you know what you're doing. It's important. And you want to feel comfortable with whoever you're talking to. So talk to people. That's something that we strongly encourage.
So we still have a few minutes left. If there are any other questions, looks like we've got another one here. Amy says, so for those of us in that situation where we can't get private long-term disability insurance because it's too late due to pre-existing conditions, what are the other options?
For disability, I don't know that there are any. For private insurance, that is. Social Security, if you have not already done so, you can apply for Social Security. Isn't just for retirement. They offer disability benefits and you can apply for those. It's not a vast sum of money, but it's usually a few $1,000s a month, which for some people can be the difference between being able to cover their bills and not. So Social Security is definitely one. If you were employed for a number of years and now aren't, some retirement plans offered by employers have a disability component that you can access, or you can that you need to find out, because every plan's different. But there are some that have a disability component, which basically allows you to access your retirement benefits early. And again, if you had insurance at one time and became disabled and didn't make a claim then, depending on how long ago it was and the circumstances surrounding it, it's possible that you may be able to make a claim under that prior coverage. But again, it's really fact specific. That's not something I can promise to anyone off the cuff.
I'm going to put Stacy's email and my email in the chat. So if I know this kind of when it marinates with people, other questions come up. So feel free to email us.
And if you have questions that
something else occurs to you,
are personal and you don't really want to talk about in a group chat, we're happy to answer questions.
Stacy and Elizabeth, thank you both so much. This has been really informative and hopefully helpful to those who have attended today. I'm also going to put the information for CCI in the chat in case anyone wants to follow up with us as well.
Thanks everyone for sticking around for so long in the evening, dinner time on Zoom.
Looks like we've got one last question here, maybe from Haley, who says, any insight for my situation where I got diagnosed with my condition just 2 years into professional life and wasn't informed of disability options, so they chose to leave that job since they couldn't keep up with the demands and have been self-employed since, and they're wondering if they've ruined their chances of support.
I do think that it will be more difficult to get coverage, but where you're quite young, a big thing that the insurance companies look at is your age. So if you're quite recently out of school, you may be able to follow up. Also, if you were diagnosed, so you left because you couldn't keep up with the demands. If you were already disabled at that point, depending on how long ago it was, it's possible that you can make a claim under whatever insurance you had there. That if you were disabled but you didn't have the diagnosis yet, that's always a possibility. Again, we need a lot more information so that I could give you a real answer, but it's always a possibility. If you're in your 50s, it's tough to get a new plan. That's what happened with me. I'm 49 years old. I'm perfectly healthy, but they didn't want to give me the full disability policy that I requested because I'm old to them. So, and yeah, I'm irritated with myself because I should have known that too, but I just kept putting it off because I was lazy.
Well, again, everyone, thank you so much for joining us. If you're not on our CCI email list, feel free to go to the contact page of our website, which I put in the chat, and you can sign up there. Also, I'm going to be, again, sending out an email with the slides as well as a recording from tonight. So if anybody wants to rewatch or re-listen or has any other questions, please don't hesitate to reach out to myself at CCI or to Elizabeth or Stacy with any more specific legal questions that I will not be able to answer for you.
Thank you, Allison. Thanks, everybody. Sticking around.
Thank you so much.
Bye, all.
Bye, everybody. Have a great night.
Bye.